George Court is considered before the maximum ready to see it. However, I just want the court to note that counsel that have pressures on the court and I have this is the ruling. The accused, Musa Ibrahim, also known as Pressure 847, stand charged with 8 counts. 4 of these 8 counts are for hate speech. Under section 26, section A1, A, C, and 2 of the Computer Misuse Act of 2011 as amended, where it is alleged that the said accused person between August 2023 and February 2024 in the areas of Kampala district or thereabout, or using a computer via TikTok account at Pressure 24/7, shared information which is likely to ridicule or degrade or demean and promote hostility against the persons to wit His Excellency Dr. 7, President of Uganda in count number 1, His Majesty Mwenda Mutebi II, the Kabaka of Uganda in count number 2, Right Honorable Anita Among, the Speaker of Parliament of the Republic of Uganda, in count number 5, and Honorable Joyce Nagosa Sebukwawo, this is the count number 7. Inside with 4 counts of malicious information under Section 26C, Subsection 1 and Subsection 2 of the Computer Misuse Act of 2011 as amended. It's alleged that the said accused between the month of August 2023 and February 2024 in the areas of Kampala district or thereabout, or using a computer via TikTok account at Pressure 24/7, shared malicious information relating to the following persons. 1. His Excellency Dr. 7, the President of Uganda in count number 2. His Majesty Honorable Mwenda Mutebi II, the Kabaka of Uganda in count number 4. Right Honorable Anita Among, the Speaker of the Republic of Uganda in count number 6. And Honorable Joyce Nagosa Sebukwawo in count number 8. The accused person denied all the 8 counts and applied for bail through 4 advocates, namely Masaba Raphael Gideon, Tumusime Kakulu, Tumusime Kato, and Ochida Hope. The accused presented 2 sureties, namely Nabos of Brenda, age 35, who operates a cosmetic shop and sister of the accused. Ibrahim Sembata Matira, age 32, who operates a phone and accessory shop and friend of the accused person. The state represented by Large Chief Setatone, Richard Bidi Kumbuka, opposed the application on the following grounds. And the best of the affidavit reply deponed by Detective IEP Pamizo Agre, and the grounds are the following. That the applicant or accused person has no fixed place overboard, that the area local council, one chairperson of Chaki Zone in Najana Nkumbi, informed him in the annexure C to the affidavit reply, stating that he has never been a resident of his area. That he was arrested from Excelsis Garden Hotel in Ntinda, where he had lived for 2 months, and that the charge sheet has his residence as Kauga in Mukono, and therefore the accused person's residence is not clear, yet it's a key factor to consider in granting bail. The accused has no credibility given the fact that he has no place overboard, that his chances of absconding are high and therefore is of flight risk, given that he lacks a fixed place overboard. Inside the case of, for instance, Onebe versus Uganda, stating that it would be risky for his court reason accused person who has no fixed place overboard. It was further the establishment of the Land Chief Setatone that the 2 sureties are not substantial, that Numbers of Brenda, a sister of the accused person, is a tenant at Church Zone without credible source of income, or Mr. Sembata Ibrahim Matia was disowned by the area chairperson of Muzana Zone in Chisenyi, where he allegedly stays. He concluded that the two accused persons, that the 2 sureties have no fixed places overboard, and that Numbers of being a tenant can shift anytime, and on credible sources of income. He cited the case of Mugera John versus Uganda. He further stated that the case is of public interest, and he cited the case, the ruling of Justice Tibulia in the consolidated administrator's application 45, 46, and 47 of 2015. It was further the state's submission that the accused will be unsafe outside prison and that the offense is grave in nature. He prayed that bail will be denied and that if this this court is inclined to grant bail, it should impose extremely stringent bail conditions. In rejoinder, Mr. Masaba submitted that the offence is not in grave in nature as alleged by the state, as attracts the maximum sentence of 5 years in prison upon conviction. That the AIS chairpersons who disowned the applicant at the shootings were intimidated by the investigating officer. That the state already has enough evidence against the accused person, and that's why we will charge him in court, and that therefore the accused person shall not interfere with the investigations. It was the submission that the shootings are substantial and that numbers of being a tenant cannot bar her from being a competent surety as long as she can ensure that the accused person attends trial. He confirmed that the accused has a fixed space of abode at Chaki Zone and Kapoli Budaka, where he stays during holidays with his mother. He prayed that the court listed the accused person on very lenient terms, virtually on non-cash bail. The issue now before this court is whether all the accused person has satisfied the ground for release on bail. It's straight law that every accused person has a constitutional right to apply for bail, which court has discretion to grant or not to grant in accordance with the law. I've carefully addressed my mind to paragraph 13 of the Constitution, bail guidance for cost of judicature, practice direction of 2022, actually paragraph 13 on consideration for grant of bail. The same paragraph says that the court shall consider the following in handling a bail application. 1. The gravity of the offence. B. The nature of the offence. C. The antecedents of the applicant insofar as they are known. D. The possibility of a substantial delay of the trial. E. The applicant's age, physical and mental conditions. F. The likelihood of the applicant to attend court. E. The stage of proceedings. H. The likelihood of the applicant to commit another offence while on bail. J. The safety of the applicant, the community, and the complainants. K. Whether the applicant has a fixed place of abode within Uganda, or whether he or she is ordinary resident outside Uganda. L. Whether the applicant has sufficient sureties within Uganda to undertake that the applicant shall comply with the conditions of his or her bail, among others. I note that the residence of the applicant is not clear. The charge sheet has his residence as Kauka Mukono, and when the charges were read to him, he never denied this particular fact. Later introducing him came from Church Zone in Najana Kumbi. To see a person will see one assist disowned the said accused person as case said that not a resident of the area. There is also another letter from Kapoli Nibudaka where they allege that he stayed with Maza during holidays. Upon the police, he was arrested from a hotel in Itinda where he stayed for 2 months. In light of paragraph 13(1)(k) of the bail guidelines, I don't find the accused person to have fixed space of abode. The evidence on record shows that he stays in Church Zone, Kauga in Mukono, Kapoli in Budaka, and the hotel in Itinda. Paragraph 15(1) of the bail guidelines sets out what court has to consider in defining surety substantial, and these include the age of the surety, work and residence service of the sureties, surety numbers of render as a place of work and residence at Church Zone, and managers to the tenant will also assist the accused person. In light of paragraph 15(1) A and E of the bail guides, I find her substantial. However, suite number to Mr. Sembatia Ibrahim Matia has no clear place of residence, as he was disowned by the area chairperson of the zone where he alleges to be staying. He has no clear relationship with the accused person, and may state that is his friend. And in light of paragraph 15(1) B and E of the bail guides, I don't find Mr. Sembatia Ibrahim Matia a substantial suite to stand for the accused person. An applicant who has no fixed place of abode and without substantial sureties cannot be released on bail. If court did so, it would assume a risk, as stated in the case of Francis Onebe versus Uganda, which was cited above. I'm not ready to assume this risk for the reasons stated above, and for those reasons, I do reject the bail application and further demand that Tuesday 26th of March 2024 when the case shall come up for mention.
verify. One, the validity of the recommendation letter to the accused person or the applicant. And the recommendation letters, the recommendation letter for the applicant, numbers of render, and people are doing same budget. We instructed the police officer, Detective AIP Bamuziizayo Alfred, who is the investigating officer, one of the investigating officers of this matter, to ensure a thorough verification of the same. He did so, and thereafter saw an affidavit which we filed in the worship and served home to accuse. Yes, this morning. Okay. Your worship, I verify to the state captain the verification, but from key. Your worship, confirm that the investigating officer in this matter referred to paragraph 2 of the said affidavit. Paragraph 2. And we appreciate your worship the fact that this accused person is charged with 4 counts of hate speech and malicious information. That's the paragraph. In respect to the accused person himself, your worship refers to paragraph 6. The letter which introduced him was received, and we annexed it as the annexed. Annexed. On verification, it was found out that the applicant, who is the accused person, has never been a resident of that place. The chairperson LC1 confirmed that through his letter, which is the last been a resident of the place which is in the that's it zone. Yes. Paragraph 1. This is paragraph 7 of the affidavit. This annex chap is marked. So the letter of chairman confirmed the next step. Yes. And your worship, that explains there's some connection between the chairperson's letter and the place where the accused person or the applicant was absent from. The applicant was arrested from a hotel called Alexis, which is found in Tingishinda. He had been there for 2 consecutive months. An implication of that is that he does not have a fixed place of abode, which is very critical to consider why God is granting for Your Worship, because the accused person does not have a fixed place of abode, it became extremely difficult for police to locate him and arrest him. I'm trying to arrest him, to locate him and arrest him. Locate and arrest him. I try to paragraph total of the evidence. Your Worship, as I submit in that respect, in considering whether or not an accused person is eligible to resist bail, the place of residence or fixed place of abode plays an important role because it speaks to the credibility of the accused person or the applicant and the possibility of rearresting him in case he absconds. And when we talk about a place of abode, we are meaning a fixed place of abode. A fixed place of abode. Which is not here in the instant case. And Your Worship, allow me submit that a situation where an accused person with this respect exhibits no credibility, then who are we to assume his worth? Secondly, failure to have a fixed place of abode makes him a flight risk. Makes him a flight risk. That the chances of him absconding bail in case he's released are so high and in that respect, court cannot assume the risk. Your Worship, I will refer you to the case of Honorable Francis versus Uganda. Honorable Francis versus Uganda. High Court is yes application number 242 of 2021. I'll furnish this court with I would just want to quote something from that case. That bail is founded on a trust system. Bail is founded on a trust system. And if any or the whole of this trust is put into question, the court cannot assume the risk of releasing the applicant on bail. And this is exactly like happening in this case. We pray that this court does not take the risk or assume the risk of releasing him on bail since the trust in him is in question. Prosecution would have had nothing to say had the applicant proven that he has a fixed place of abode. Sembatia Moses. Sembatia Moses. Sembatia Ibrahim. Sembatia Ibrahim. It was, yes. It was, upon verification, it was found out that Sembatia Ibrahim is no longer resident. It's no longer a resident of the area, which appears in his introduction letter. Yeah. Yes, Your Worship. I am calm, Your Worship. But in the verification, Your Worship, now after David. What's further? No. I want to refer you first of all, paragraph 8. Paragraph 8. Where we attached his introduction letter, which is in this book, as an extra F. As an extra F. Yes. Then I want to refer you to paragraph 10 of the affidavit, in which the chairperson LC1 was categorically clear that the said surety is no longer a resident of that place. That's the same. Yes. And that letter is marked as annexure G. I refer to paragraph 10 of the affidavit. Annexure G. Annexure G. That's correct. Never look at this one. No record. It is still correct. Yes, I'll come back to him as well. On the same of God. Then, in respect to numbers of render, Your Worship, we attached the letter introducing her as an extra E as per paragraph 8 of the affidavit. And upon verification, numbers of render is a tenant in one of the in that area, and she does not have a fixed place of her own. She's a resident, but she doesn't have a fixed place of her own. Has she 10 times? Yes. Has she 10 times? Yes. And Your Worship will refer you to paragraph 10. Paragraph 10, yes. No, 9 of the Your Worship, allow me to submit about those two shootings. For a shooting to be substantial or to be considered substantial, there are several considerations that court must look at. One of them, as I said earlier on, is having a fixed place of her own. Which does not exist in our instant case. The current residence of Sembatia is not known. Nambozo is a tenant who is temporal that can shift anytime. And the applicant much as it's not a surety. Cannot be placed anywhere. Now, the implication in respect to Ibrahim, the applicant, the surety, is that he likes to know that he has a fixed place of abode. And those are all transportation. The second thing, Your Worship, that God looks at is whether the surety is capable of meeting the bond terms in case the applicant has yes. We're talking about I'm a businessman, business lady in places, they couldn't even locate that. No one can locate the business that they were talking about. That is one group of. Two, they have to show that by producing bank statements, which court can look at and stimulate it and say this person is worth the interest in this person or the applicant. None of them did that. It is also important to note, Your Worship, that another way of demonstrating that is by furnishing titles. By furnishing titles, land titles in this respect, to show that the surety can, in case the applicant can sell that land. First of all, show that he has a fixed place of land or abode. Secondly, that he can sell that piece of land and reimburse. This was never done. None of the sureties presented is able to do so. Then, the other way, Your Worship, is demonstrating as a surety that they know the applicant and where they live. In which case they are able to control the accused person in case he has no suspect. I want to just refer you. Ibrahim, one of the sureties, simply saying is a friend, the applicant. I don't know whether it's a temporary friend or a permanent friend, but simply said he was a friend to the applicant and did not mention to this court that he knows where he stays. Your Worship, that explains why. Even his residence is not up to date. Your Worship, I'm assuring that these service persons were released on bail. Would he go to another hotel? And in case he goes to another hotel, will the surety be in position to control him practically? None of the sureties has a passport. They don't even have a passport. The best they can do is to use correspondence in the case the accused person absents. And we have an experience of Kakweza who was charged with the cyber harassment, who ran away. These are things we are talking about and they are a reality.
Communicate to your lawyer.
We are talking about the surety, not the accused person. Your Worship, of Mogera John versus Uganda. Mogera John versus Uganda. This is miscellaneous application number 0021 of 2023. 0021 of 2023. International Fines Division of the High Court. This was by Justice Lady Justice Alice from Hands. Your Worship, while the judge was denying bail to the applicant, she referred or she relied on the ruling of miscellaneous application number 002 of 2022. 002 of 2022 by Honorable Lady Justice Elizabeth Jane Alviza. Who, on page 11 of that ruling, emphasized the importance of credible sources of income for a surety. And in that case, because the surety is failed to demonstrate that was a reason for denial of the application. Your Worship, I have a copy of the ruling of 0021 of 2023. And my submissions are based on page 13 of the same. A copy of the same is here, Your Worship. Then also for French. And Your Worship, just to emphasize that, it is worse, especially when the matter is of public interest. This is a matter of public interest. The treatment given to matters of public interest is different from other matters. And where a court finds that a matter is of public interest, then, Your Worship, Justice Margaret Tugulia, emphasized in miscellaneous applications number 045, 046, and 047 of 2015 on page 10 of that ruling. Where she emphasized that in considering whether an accused person or an applicant should be released on bail, until the matter is complete. The applicant in custody until the matter is complete. The applicant attacked very important persons in this country, that even his life is insecure. And actually being in custody is for his own benefit. Being in custody is for his own benefit. In fact, if I were him, I wouldn't even mention what applications to make. First of all, I have a copy of this ruling. For court.
You are saying that he's safer in prison?
He's safer in prison, Your Worship. And Your Worship, it's not only speculative, but I would refer you to paragraph Paragraph 5 from the affidavit. From our investigations, Your Worship, is that there were clear signs that if the public just got hold of the applicant, he would be dissected into pieces. So he is safer in custody.
People would like to object to that.
You will get the text of the
These are our investigations. You can also present your one. Your Worship, with that submission, therefore, that the applicant is safer in custody. Besides, it is the applicant is an administrator of pressure of a Twitter account called the Pressure 24/7. He's the administrator of that account. So how is it? Pressure at Pressure 24/7. At Pressure slice 24/7. I refer to paragraph 11 of the affidavit. I refer to paragraph 11 of the affidavit. TikTok. Yes, TikTok. Yeah. Yes. What is the implication? Is that once he gets out of custody, the possibility of him deleting and interfering with the investigations are so high. And yet this TikTok account is a source of investigation. Your Worship, I'm not an expert, but once you're an administrator, then you're capable of doing anything on that account which you add in it. Besides, that said,
you're saying we have to investigation.
Yes, exactly.
Conclusion?
Your Worship, I just want to furnish you with a copy of the ruling of this application 045, 046, and 047 of 2015. Your Worship, Your Worship, it is our prayer that you find that it is presented not substantial enough. I just want to highlight something small before I talk about the submission which my brother brought in. When the applicant appeared before police, he presented his place of abode as Kookie appeared in the corner of Akamkono. His place of abode? Yes, as per Annex 30. As per Annex 30. Page 1 of Annex 30.
Annex 30 is the church.
The church.
The church of Kabaka.
Yes. Well knowing with impunity, with dishonesty, knowing that he was lying. So, if he is fond of lying, should we not trust him? If he has exhibited signs of dishonesty, then who should place honesty? Who should believe that the applicant is honest? As a bishop that you agree with the prosecution, that no one should trust him. And the only way you cannot trust him is by ensuring that this application is dismissed. Your Worship, my brother for the applicant sought to to bring in another ship. Introduce another ship.
Just introducing a place of residence. An alternative place of residence. That's the question, Mr. Masaba? Introducing another place of residence. Make it free.
To make it free residency, which is very good. We do appreciate. What does that signify? That this court may not get him in anywhere, and none of these shooters, I don't know whether in court, will ever trace his residence or manage to prevail over him in case this applicant absconded bail. Having 3 homes for an applicant who is not a corporate makes him more of a flight risk because he depends on phone to survive, being that he's not corporate. While other people go to offices, he's on phone to make money from phone. So that makes him too uncorporate and trustworthy.
So what can't supposed to survive on a phone?
How? Where would you find him? Where is his place of address? Because your worship, I don't want to speculate. But the issue of address is a matter of fact. And besides, prosecution pledged to verify their documents. If, for example, Banani brothers knew of that, they probably took instructions prematurely without interviewing the applicant. I'm not accusing them, but they should have brought this information that time when they were making this application. This is an afterthought. This is an afterthought because they are operating no bootstrap. As the prosecution is proceeding to verify the residence of the accused person or applicant, they are busy operating in a bootstrap because we should have verified that. And now that we can't verify that, we pray that your worship court finds him further that he doesn't have the express of a court. Your worship, in a nutshell, these are this person as per an extra Your worship, as per an extra B, that this person is charged with 8 counts. 4 for hate speech and 4 for malicious information. These are serious kind of charges or counts which are multiple in nature. They are multiple in nature. Coupled with the fact that he was on fishing spree for witnesses, for sureties, whom we believe are commercial, we pray that this court denies or dismisses his application for bail. To the worst, just in case this court has closed its eyes to these glaring gaps in this application. We pray to have that. Just in case this court closes its eyes on the glaring gaps in this application, right from the applicant, the sureties, then we pray for extremely stringent terms.
What are most extreme?
Yes, this is prosecution. I mean, this is prosecution.
So you pray that he pays 30 million cash.
And we are saying in case this court, which of course our prayer is that court should dismiss the application. But in case this court exercises its discretion, then the terms should be extremely harsh. Not harsh. Agitated. Yeah. And these terms we are talking about, which we even don't want to mention, but for example, posting a land title, posting a land title, if court is inclined, he has to post a land title in his name. Yes, demonstrates by way of an account to show that he's worthy, trusting himself. Your Worship, they'll also be posting his passport. Among others, who's operating.
Who is it council? No, it's one council. Choose amongst the four of you and this is one council that join.
Thank you, Your Worship.
This is most senior. Put Mr. Masao. Mr. Masao, please.
Much of that, Your Worship. Your Worship, I have carefully listened to the Land Chief State Attorney. The Land Chief State Attorney's emotional submissions.
Objection, Your Worship. These are not emotional submissions. These are professional submissions because they are based on law. I pray that you will do that.
And so we can very much emotional.
Yes.
Your Worship, with apologies, I will withdraw. I'm driven by that because
I'm writing you with the because that is emotional submission.
Your Worship.
Yes, seminars. Are we doing what you are?
Much of that.
Now proceed as we are doing.
Thank you, Your Worship. Your Worship, to start with, they also submitted that the accused is charged with several offenses. Your Worship, looking at these offenses, they are not that grave in nature. Your Worship, a quick look at the punishment is between paying a fine and imprisonment of 1 year to 5 years.
What's the maximum period in prison?
That's 5 years, Your Worship. And the minimum is a fine. Your Worship, this is not a very grave offense, like murder. And even in murder cases, Your Worship, court grants bail. So I invite court to disregard. Submissions that the accused has multiple offenses against him as a ground for not granting him bail. Your Worship, counsel submitted that the accused does not fix place of abode.
And you're saying that he has a success of abode where?
Your Worship, we earlier informed the court.
Because the accused has a fixed place of abode and
We still maintain that he has a fixed place of abode at Church Zone. And his mother's home during the school holidays in Budaka.
address me on the instance of Kabaka.
Your Worship, I want to first address court on the letter reporting the residence of the accused. Your Worship, the LC1 does not deny that he authored the first letter introducing the accused person as a resident within church zone. Not anywhere in his letter does he deny that he authored that letter. Your Worship, I would like to invite court to our earlier submission that threats from investigating officers.
So I think that the chairman of this one was very afraid.
Yes, he does not even deny authoring the letter introducing the accused person. These were threats by the investigating officer.
It is from the purpose proceed.
That of that, Your Worship. Your Worship, though, to us, we state submitted that and gave an exhibit B, which is a charge sheet, where it is stated that the residence of the accused is Kabaka village in Mukono. Your Worship, this is not trial that we are producing evidence. However, we note that the document that is relying upon is signed by the officer preparing the charge and the magistrate. We do not have time to examine and find out how was this document prepared and brought in court.
You are saying that this is a state document.
Yes, Your Worship.
So you know what they wrote.
Yes, Your Worship. And that is the officer preparing the charges. Your Worship. It is an allegation by the investigating officer that he arrested the accused from a hotel in Chisasi, where the accused had stayed for 2 months. Your Worship, there is no any proof or evidence attached to this affidavit that the accused person was actually staying in Chisasi. Your Worship, just as they have provided several evidence on this affidavit, there is no single, even a receipt from the hotel to prove to court. So invite court to actually disregard such evidence that is made by an investigating officer whose task is to ensure that the accused is left in cells. Your Worship, for the first time I had evidence from the bar that the accused is likely to be subjected to mob justice by my colleague. Apart from merely stating this in the affidavit, there is no evidence by the state that actually the accused will be subjected to mob justice. As we can see in court, Your Worship, the sympathizers are so many. I would pray that Your Worship will disregard the prayer of denying the accused the bail, because there is a likelihood of any mob justice on him. Your Worship, further, the Land Chief State Attorney presented to court that one surety Nambozo Brenda is a tenant and does not have a fixed place of abode. My simple understanding, Your Worship, of having a place of abode is that you have somewhere you reside. The ownership Your Worship, I back up this with direction number 15 and the Constitution bail guidelines for courts of adjudication. where court only has to get the, where considering a surety, court would look at the age, work and residence of the surety, but not that the surety should own a home for him to become a sound and substantive surety. Your Worship, the LOC even confirms that actually Brenda is a resident within church zone. So I will pray, Your Worship, that court finds Nambozo Brenda a sister to the accused, Your Worship, she's also older than the accused, so she has influence over the accused person by age, and she will ensure that he appears before court. Further, Your Worship, on the second surety, before this court we introduced Ibrahim Sembatia Matia as a resident of Muzanga zone. And Your Worship, during the submissions I had of Sembatia Moses,
It was withdrawn. And what we have is Sembatia Matia.
Your Worship, I did not hear counsel withdraw that.
This is still the court of the matter.
Thank you, Your Worship. Your Worship, in this regard, the same spirit we informed the court earlier that the investigating officer has intimidated the LC1 who introduced the accused person. We still see it on Ibrahim Sembatia Matia. The LC writes a letter. He does not deny having introduced the surety to court. But he merely asserts that he does not know if the surety is no longer a resident in that area. Your Worship, I would pray that since the surety presented to court the Republic of Uganda national ID, which has not been found to be a forgery, because if it was, our state would have informed us, what should we find? Ibrahim Sembatia Matia as a sound surety. Since he can be every found possessing of his national ID and his workplace. Your Worship, we had a state submit that the accused is likely to interfere with investigations since he is the administrator of at pressure 24/7. So he's likely to delete. Your Worship, I believe by the time a file was compiled and taken to the state attorney to charge the accused, evidence has been collected that moved the Land Chief State Attorney to sanction the charges against the accused.
Even if he deletes
The evidence is very Yes, Your Worship. Your Worship, we have 4 charges and we have about 8 counts. If evidence was not there at the time of charging the accused person, they would not have charged all these 8 counts. We believe there is no likelihood of the accused interfering with the investigations. Your Worship, further, that even the investigating officer determined enough that it is evidence that actually he has collected the evidence. And Your Worship, I don't have the authority with me here, but I'd like to cite it for court. This is Bujam versus Republic. PANGU versus Republic. Your Worship, it's a 1973 East Africa Law Reports at page 200. 1973.
East Africa.
Yes, at page 282. Where it was held.
PANGU.
Yes, versus Republic. The 1973 East Africa reports at page 200. It was held that circumstances where an investigating officer has shown an affidavit it is court held that it was a simple act that an allegation, fears or suspicions then the sky is the limit and one can only, then there will be no occasion for bail if court believed that on just a mere allegation, fears and suspicion of the affidavit of the investigating officer. Then the sky will be the limit and there will be no bail. Your Worship, also, we had State Attorney mention that the sureties should have businesses and should be people of financial muscle qualified to be a surety. My Lord, in the simple duties of a surety is someone when he or she will ensure that the accused person appears in court. We humbly pray that this court disregards the prayer.
So it is not based on finance.
Yes, Your Worship.
Financial must be one day.
Yes.
Find out.
Your Worship, this was in Kayongo versus Bashir.
Kayongo versus Bashir.
Kayongo Bashir versus Uganda. Kayongo Bashir versus Uganda was a miscellaneous application number 158 of 2019.
2019.
Yes, where court held that court noted that the onus is to prove the permanent place of our abode and not to produce titles. Court is lenient. Considering that the fine, if court sentenced him to a fine of 70 currency points, would not even be more than 3 million shillings, Your Worship. I should put down the prayer for court to consider bail of non-cash. Thank you, Your Worship.
You're going to give me around 20 minutes.